Good evening, everyone, and welcome to the Planning Board Public Meeting, June 13th, 2019. Please join me in a salute to the flag. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be advised that this meeting has been duly advertised according to Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, otherwise known as the Sunshine Law. Notice of the 2019 annual meeting schedule has been provided to the officially designated newspapers, to the Township Clerk, and posted on the bulletin board here at the Hillsborough Township Municipal Complex. Notice has been provided that this meeting would take place this evening on June 13th, 2019 at 7:30 p.m. at the Hillsborough Township Municipal Complex. So first up, we have a new member. Hey, Nate. All right. So we have to do the swearing. Who, Mr. Mayor? All right. So I guess you guys can
raise your right hand. Repeat after me. I state your name.
I, Nathan Santamita,
Do solemnly swear
do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith
that I will bear true faith
and allegiance to the same
and allegiance to the same,
and to the governments established
and to the governments established
in the United States
in the United States
and in this state
and in this state,
under the authority of the people,
under the authority of the people,
and that I will faithfully,
and I will faithfully,
impartially,
impartially,
and justly perform
and justly perform
all the duties of the office
all the duties of the office
of Class 4 member
of Class 4 member
of the Planning Board, alternate 2,
of the Planning Board, alternate 2,
to the best of my ability.
to the best of my ability.
So help me God.
So help me God.
Congratulations. Welcome.
Congratulations. Thank you.
Okay.
So I said, welcome, Nate. You know, it's a pleasure working with you a little bit on the capital planning.
Yes.
So, I know
Thank you very much.
you do good work, and look forward to having you here.
Thank you. So do I.
Next up, roll call. We got to see who's here now.
Mayor Duffler,
Here.
Mr. Wagner,
Here?
Mr. Capani,
Here.
Mr. Beeson,
Present.
Chairman Sarachi,
Here.
Mr. Julian, Mr. Weinstein, Mr. Scobo,
Here.
Mr. Hestag,
Here.
Mr. Deb,
Here now.
oh,
My apologies.
and Mr. Sentimore.
Timing is everything.
Here. You'll get it.
I will.
Excellent.
All members of the board are eligible to vote tonight.
Next up, we have consideration meeting minutes from April 25th, 2019.
Mr. Chairman, the eligible members are yourself, Mr. Lapani, Mr. Wagner, Mr. Scobo, Mr. Hestag, and Mr. Deb.
Okay. So may I have a motion to approve the April,
I'll make that motion to approve.
okay, do I have a
I'll
second?
second it.
Okay, we have a first and a second. Any comments from the dais? Seeing none, roll call, please.
Mr. Wagner,
Yes.
Mr. Capani,
Yes.
Mr. Sarachi,
Yes.
Mr. Scobo,
Yes?
Mr. Hestag,
Yes.
and Mr. Deb.
Yes.
Okay, excellent. So we have no considerations this evening, no planning board business. I'll just open up to the public if there's anything that public would like to provide comment to the planning board that are not on this evening's agenda. May come forward. Okay, seeing none, which we have no considerations of ordinances. So we will move on to applications. First up is an extension request for the Terrace Industrial Park application, 08-PB-08-MJF.
Good evening, Chairman and Planning Board members. My name is Julie Hirsch. I'm an attorney with Archer and Griner.
Ms. Hirsch, Rules of engagement. Speak into the microphone, as if you were, giving a concert. The only important person is the man sitting behind you with the earphones on.
Very good.
Yes, even more than stenographer.
Go ahead.
All right,
Okay.
very good, thank you.
Yep.
Thank you for listing this tonight. I'm here on behalf of Guastella Family Associates. They are the owners of the Terrace Industrial Park. This is a subdivision that goes back decades, I'm afraid to say. It was originally approved, believe it or not, in 1980 as a 13-lot subdivision. It has, since that time, been continuously in the I-1 industrial zone. The present subdivision is a 10-lot subdivision, which was approved, the first planning board approval for the 10-lot subdivision was granted in 2008 under the Permit Extension Act. The approval was extended through to 2016. This board has granted 3 one-year extensions on top of that, which take us to a deadline, essentially an expiration subdivision this month, June 30th, 2019. This is an extension request. It's a little bit unusual. I'm not sure that, I've done one of these before, and the board may not have heard one of these before either. It is pursuant to Section 21 of the Municipal Land Use Law, which provides for what the law describes as tolling. And I'm sorry, I'm looking at your court stenographer and thinking I should just confirm that the public notice for this application is in order. We did provide an affidavit of service and publication.
Yes.
Thank you very much. So I was saying that this is not a standard extension as you may be used to. It is a request for, we'll call it extension, but it effectively is a tolling of the approval provided for under Section 21 of the Municipal Land Use Law that allows for a development which has been prevented directly or indirectly from proceeding as a result of the legal action of any state, municipal, or other government agency, which action has been taken to protect the public health and welfare, allows and the developers otherwise able, willing to proceed, as the statute says, that the running of the approval shall be suspended during the period of that legal action, directive, or order. What this, I'll put that in simpler language, what it means for this subdivision is, going back a number of years when it was a 13-lot subdivision, this property, the total of which was purchased by my client from Hillsborough Township. There were 3 lots at the end of the subdivision. After that approval was granted, there was soil testing done, and they discovered that that approximate 3-lot area had been used as a municipal landfill. As a result of that, an agreement was struck between Hillsborough and Guastella Family Associates to deed back that 3-lot property and to have the township remediate, clean up, do whatever was necessary, whatever DEP would require for those 3 lots. Guastella Family Associates was left with the remainder of the 10 lots, subject to a series of conditions that were stated in this agreement from the year 2000. And as a result of that, an easement additionally was given to the township to allow for the township lot to be developed and to allow, more importantly, for the township lot to be remediated. So what is now the township lot is lot 1.05. The remainder of the 10-lot subdivision is lot 1. At the present time, it is our understanding, based on the report we submitted with the application, that the remediation or cleanup, whatever specifically DEP is going to require, has not been done on the township landfill lot. We do have an expert with us tonight, Eric Schlock, who is a licensed LSRP, who will just tell you very briefly about the status of the township landfill lot. As a result of the fact that that lot has not been remediated or cleaned up, and we understand will have to be cleaned up or closed, whatever terminology you want to use, whatever DEP requires. The remainder of the subdivision is pretty much on hold until that lot has been cleaned up and is ready either for sale by Hillsborough Township, or I don't imagine you would be developing it, but you would be selling it to someone else who would use it for industrial purposes. And when that happens, the cleanup and the sale of that lot, then the remainder of the subdivision will be ready to go forward. We weren't quite sure how long of a tolling or an extension to ask for, because of course we do not control Hillsborough Township's negotiations with DEP, but I guess I had suggested 4.5 years, and I would say 4.5 years or less if the township is able to obtain the remediation approval from DEP in a shorter period of time. So that is what is being requested. My only witness tonight is the LSRP, Mr. Schlock from Peak Environmental.
Mr. Chairman, just for the record, before Ms. Hirsch's witness is called, I'd like to place in the record the full language of the statute that she cited, which is NJSA 40:55D-21. It reads, in the event that during the period of approval heretofore or hereafter granted to an application for development, the developer is barred or prevented, directly or indirectly, from proceeding with the development otherwise permitted under such approval by a legal action instituted by any state agency, political subdivision, or other party to protect the public health and welfare, or by a directive or order issued by any state agency, political subdivision, or court of competent jurisdiction to protect the public health or welfare, and the developer is otherwise ready, willing, and able to proceed with said development. The running of the period of approval under this act or any other act, any act repealed by this act, as the case may be, shall be suspended for the period of time said legal action is pending or such directive or order is in effect. Therefore, I would argue that the applicant's obligation is to meet the criteria of the statute, which is to indicate that they are ready, willing, and able to proceed with the development, that there is a agency directive or court order that indicates that they cannot for public safety or health reasons. And at that point, the board can consider whether or not to grant any tolling period. So I will leave that to Ms. Hirsch. The case is her proofs.
Very good. If I might respond to that. In addition to what is in the statute, the October 4, 2000 agreement between Guastella Family Associates and the Township of Hillsborough does provide the basis for this tolling, and it really does need to be tied into the statutory provision, because and I believe I cited this in my original submission letter of March 8th. In the section of the 2000 agreement that talks generally about the township's obligation to clean up the landfill and to do whatever is necessary, and the obligation of Guastella to convey the lot back and provide an easement, all of these different various reciprocal requirements. There's a discussion of the amended subdivision approval, which is the subdivision approval that we're looking at now. The original approval was 13 lots. The landfill lot was extracted from that. Pursuant to the agreement, 10 lots were left with the developer, and In that section that talks about the amended subdivision, it states, furthermore, since completion of the closure of the landfill by Hillsborough will require an indeterminate period of time and access by Hillsborough through the remaining area, which is the 10-acre subdivision, the failure of the planning board to allow a reasonable period for the tolling of the amended subdivision shall be deemed unreasonable. All right, so this was a commitment made by the township back in the year 2000. In other words, to allow this subdivision to remain in place until such time as the township had remediated the landfill lot. You will hear more about the status, but the bottom line is that that remediation has not been completed. So in terms of ready, willing, and able, I believe in my second cover letter, I refer to the fact that the applicant has received a number of approvals recently for extensions of approvals. I did not provide them to the board, but I do have a copy of them here in reference to my April 24 letter. The first one is the Hillsborough Township Municipal Utility Authority, and that approval is dated February 27, 2019. I don't know if we want to mark this A1 for the record.
Yeah, which says what? I think the marking it and
It is a resolution dash approval of a sanitary sewer connection for Terrace Industrial Park, Block 185, Lot 1. And then there are, it's an approval subject to a series of conditions.
mark this A1. I'll pass it out to the board.
Okay, and I've just marked A2, the Somerset County Planning Board approval dated February 21, 2019.
A2 will be a letter which is sent to, actually, the chair from the County of Somerset Planning Board dated February 21st, 2019 regarding the project.
And the last approval is the February 27, 2019 Delaware and Raritan Canal Commission staff review letter recommending approval at the last page, issued by John Hutchinson, Executive Director. Mark that as A3.
Just for the purposes of the record, Ms. Hirsch, according to the various documents, the application currently is a 10-lot industrial subdivision, of which 1 lot is going to be used for the detention basin and 9 lots for industrial use. Is that correct?
That's correct.
A3, Mr. Chairman, will be marked. It's a letter from the DNR Canal Commission dated February 27, 2019, regarding the project in question, signed by, page 4, John Hutchinson, Executive Director. I'm also going to pass this around to the board.
All right, so with those 3 recent approvals or extension of approvals, the applicant is ready, willing, and able to proceed with this subdivision once the DEP remediation is completed. The agency directive or order, I think it would be best if Mr. Schlock addressed for you so that you can understand how that fits into the status. May I bring him up?
Yes.
One of you to share that microphone, or you take the handheld, either one.
Okay, thank you.
It's the green light, it's on, it's on, it's on.
Very good. Thank you.
Microphone. Oh. Sir, testimony. Raise your right hand. Testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name, spell your last name for the record, and indicate by whom you are employed.
Eric Schlauch, S-C-H-L-A-U-C-H,
You gotta get closer to the mic.
employed by Peak Environmental, LLC.
Your witness, counselor.
Very good. Mr. Schlauch, would you please give the board the benefit of your credentials?
I am a managing partner at Peak Environmental and a licensed site remediation professional in the state of New Jersey.
Okay, very good. What documentation have you evaluated before preparing your report dated March
Can you
8th,
use the microphone,
2019?
please? Can you use the,
You need to use the handheld, and I would suggest
Sorry
counsel
about
get
that.
a little more
more background.
qualifications, Mr. Schlosser, so that the board can decide whether or not to accept his qualifications as a engineer in an LSRP.
I've been practicing environmental site investigation and remediation since 1988 or so in the state of New Jersey. I have a degree in geological engineering from the University of Missouri, and I have remediated and been involved as LSRP of record hundreds of sites in the state of New Jersey.
Have you appeared before any other boards?
I've represented applicants as well as planning boards, yes.
Okay. Anyone have any questions or objections?
No?
Okay, I see a lot of shaking no, so we'll accept your credentials.
Thank you.
Okay, Mr. Schlauch, have you prepared a report that was submitted to the board dated March 8th, 2019?
I did, yes.
And what documentation did you review prior to preparing that report?
My office obtained all the files that were available through OPA requests from local records, town and county, as well as New Jersey Department of Environmental Protection.
And if you could please summarize what that documentation showed you concerning what is known as the Weston Road landfill.
It revealed that in approximately 2001, the township had entered into what was then known as a memorandum of agreement, which is a voluntary agreement of which no longer exists. It's no longer a mechanism accepted by DEP. But it was a voluntary agreement that the township entered into with New Jersey DEP to obtain DEP's oversight of the township's investigation and remediation of the landfill property. The township retained birdsall engineering, and under DEP's oversight, there were several reports submitted to document the initial investigation of the property. Those reports include what's known as a preliminary assessment report, which Birdsall prepared and submitted in 2005, a site investigation report in 2001, and a remedial investigation work plan and other work plans from 2007 to 2009. And this process, as most site remediation cases proceeded through back before what's known as the Site Remediation Reform Act, which is the act that provided LSRP authority now. So before LSRP rules or the Site Remediation Reform Act came out in 2009, cases proceeded through this kind of investigation where a responsible party, such as the township, would retain a consultant, submit a report to DEP, the DEP review it, send back a letter, tell you what to do next. It was a very long, arduous process back and forth. So that's what those reports document. Those reports would, Birdsall would do some sampling on behalf of the township, submit a report, DEP would comment, and there would be that back and forth, and that's what occurred. Up to the point of approximately 2011, where the activity stopped and the MOA, the Memorandum of Agreement, was terminated. During Birdsall's investigation, as with most environmental investigations, they collected soil as well as groundwater samples, as well as some vapor samples in the area of the landfill. And I should state, the records generally show that that landfill was operated from, it's a little unclear, but sometime in the 50s through the 60s to approximately 1964, at which time it no longer accepted waste, but up to that point it was accepting dry industrial waste and residential waste. The landfill was never closed. It stopped accepting waste, but it was never capped and covered. So Birdsall investigation came in and investigated the potential impact to the environment of that landfill. They detected numerous contaminants in soil, including several heavy metals, lead, mercury, above DEP remediation standards. And in groundwater, chlorobenzene, arsenic, chromium, lead, nickel, and were detected in groundwater above New Jersey site remediation standards. So the reports that I mentioned document all that investigation. The file, however, stops when the MOA was terminated and the property, the remediation was never completed. The landfill was never closed, it was never capped, so there is a substantial amount of work that still remains to be done.
Has anything occurred
Microphone.
remediation since the termination of the MOA? And also, please tell us what that means, termination of the MOA.
The MOA being a voluntary agreement, when the township decided not to proceed with further investigation remediation, it removed itself from the obligation by canceling the agreement. Shortly thereafter, the Site Remediation Reform Act was enacted, and it really was sweeping changes in the state of New Jersey on how contaminated properties are investigated and remediated. And it puts the obligation onto the responsible parties to proceed using the same regulations that are always in place, but to proceed without department oversight by retaining an LSRP. So the process really changed from the old world of submitting reports and waiting for DEP to review everything, where now the responsible parties just follow the direction of an LSRP and cleanups can proceed much more swiftly. In this process, the DEP tracks cases now and in a database and assign regulatory and mandatory timeframes for certain milestones to be achieved, such that the DEP can ensure that cases actually reach the final remediation. So what we see in those records is that essentially no activity has occurred. And timeframes have been missed. So there are several outstanding requirements that have not been met, those including not retaining an LSRP, not completing a receptor evaluation, not completing the investigation of the landfill, in other words, never determining the extent of contamination that's back there, how far it extends, and public notice and other administrative requirements.
So under the Site Remediation Reform Act of 2012, what options does DEP have under the law, given the lack of action by Hillsborough Township?
The DEP will track those timeframes, and when mandatory timeframes are missed, the case will go back into direct oversight. So it's akin to the old world of having DEP oversight, and in other words, a DEP case manager telling the response party what to do every step of the way, establishing financial assurance in some cases, providing public notice to the surrounding community of progress on the cleanup. So it's a world, essentially a regulatory world that is not desirable. Because the DEP, when they enacted the new legislation, excuse me, really expected cases to proceed more quickly. So when these timeframes, and especially mandatory timeframes, are met, they come down pretty hard by requiring this direct oversight mechanism.
And your review of the DEP records indicates that this is out of compliance, this property is out of compliance at this time?
That's correct. In 2001, when contamination was identified and confirmed to exist above remediation standards, there was a case number assigned, and that's a 2001 case number. The timeframes, the regulatory and mandatory timeframes then that the Site Remediation Reform Act enacted are based off that 2001 timeframe. So the most important or most substantial timeframe that has now been missed was a May 2019 deadline to complete the remedial investigation, and that has not been completed, and that was a mandatory timeframe.
So just to be clear, the next step that DEP has the authority to take, given that May 2019 deadline being missed, is very specifically what?
Well, it will go into what's called direct oversight. So the case will then be required to, again, as you know, to meet this outstanding requirement to retain an LSRP, complete the receptor evaluation, provide public notice and implement a public participation plan so the public has opportunity to comment on the plans to complete the remediation, and establishing financial assurance. In other words, posting an amount of money that's equivalent to remediation such that the DEP has some direction over when that money is released and ensuring that the remediation progresses in accordance with their requirements.
Mr. Chairman, if I may?
Sure.
Yes, I could. We requested our township engineer to look into this issue, particularly the May deadline that's been brought up. And Robert Keady of T&M Associates had their LSRP, Bob, make sure I get the name right, Pierce Mackel, correct, PE-LSRP, to look into the claim that we were missing a May deadline. And I will read, or paraphrase at least, from Mr. Keaty's email to us, to the Township Administrator, Anthony Ferrara. Based on our review of the documents available and review of the NJDEP website, data miner, it appears that the Western Road landfill site case has been transferred from the NJDEP site remediation program to the NJDEP solid waste program. If it were under the SRP program, the May deadline to submit remedial investigation report would be applicable. However, under the solid waste program, the site is listed as active and not properly closed. Therefore, it appears there is no specific deadline under the solid waste program.
Well, we're a little surprised to hear that. I mean, I submitted this application in March, and that information would have been very helpful if we had had it a little bit before tonight. But at any rate, are you in a position to respond to that, Mr. Sloan?
I am. I think that it fails to recognize that contamination was identified. It may be correct to state it in that manner if it was just a property that had yet to be investigated, and in other words, contamination was yet to be confirmed. So contamination was confirmed, a case number was assigned, and I have with me tonight a March 2012 advisory that was provided for municipality officials in which the DEP advises municipalities of mandatory remediation timeframes. And essentially what it states is that if you are a responsible party, and in this case, the township owned and operated that landfill, and as such is a responsible party, then these deadlines apply.
So let me make sure for the record, sir, it is your contention on behalf of your client that if the township never remediates the site because for whatever reason, your client will never be able to develop the site, but for that.
Maybe that's a question for me.
No, that's a question for your LSRP, because you're making the argument that this is what's preventing you from developing a site that you've had approval on for nearly 2 decades. My question is, based on his expertise, is it his testimony that if the township does not remediate this site for whatever reason, your client will never be able to develop the site with 9 industrial properties on it because the township's landfill, quote unquote, is not resolved?
I think my answer to that question would be to make sure everybody understands that the primary deadline that's been missed here is the remedial investigation. And a remedial investigation is intended to define the full horizontal and vertical extent of contamination that may be extended from a property. So that has not been completed. And in other words, the contamination that is emanating from the township's property very well may go to my client's property, and the township's subsequent investigation and remediation of that property may well extend onto the Costella property, certainly then affecting their ability to develop the site.
So at this time, because you used the word may a couple of times, so there is no objective evidence that that's occurred yet? I mean, do you have any objective evidence that any type of contamination has occurred?
That's correct. We have no evidence because the township hasn't completed their investigation.
Other than what is indicated in the reports that were done, from 2005, 2006, the soil samples and the gas samples and everything else, which are discussed in your report, correct?
Right, which is the findings of the initial investigation, but was never completed.
Has the applicant done any samples, provided any documentation to any of the, by the way, when you submitted your applications to the DRCC, to the Municipal Utility Authority, and to the County Planning Board, did you indicate to them that your site is being unable to be developed because of potential environmental issues?
There was no need in the context of those 3 regulatory programs to discuss the township landfill.
That wasn't the question. Did you advise any or all of these parties that there were contentions, that there were environmental issues regarding your site which made it impossible to develop at this time, or that there were environmental issues regarding the site, whether they could be developed at this time?
I'm not in a position to answer that one way or the other because the engineers who handled those applications did not provide me with the application documents as they were submitted and reviewed by the agency. So I honestly can't answer that for you. I wouldn't want to hazard a guess.
And it's your client and it's your witness's testimony that the applicant has no knowledge at this time whatsoever what, if any, environmental impact exists on their site versus the township's landfill, of which they have been aware of the issue in question now for nearly 20 years.
No, I want to comment on that question because I think that is a very unfair characterization of the situation. What we're dealing with here is the township landfill. It existed, it was closed, the property was sold to my client without disclosing the existence of it.
40 years ago.
Right, and back in the year 2000, Hillsborough Township made a commitment to, with all due diligence, close the landfill. And additionally, to make accommodations to my client, including the tolling of any subdivision approval until that occurred. So from the year 2000, I'm sorry, Mr. Bernstein, but from the year 2000 to the present time, 19 years, the township was under the obligation to remediate the landfill or do whatever DEP required. If DEP just said after the township had completed its remedial investigation, all you need to do is cap it, you don't need to move any soil, nothing else, that would be fine. All we're looking for here is that approval letter from DEP, a closure letter from DEP, and that is what is required under the 2000 agreement between Hillsborough Township and Costello Family Associates. Before the year 2000, I don't think you can attribute the situation to my clients. That's utterly unfair and not justified by the facts at all.
No.
As the agreement indicates, the subdivision, the original subdivision went forward, and after the soil testing was done, showing the existence of the landfill conditions, the parties got together, they worked out an agreement to figure out how the contamination would be remediated, how the subdivision could work until it was remediated, and everything went forward from there.
So let me ask a question, Counselor. Your client got approval for this subdivision in 2008. And you've been back, not you, but the client's been back for an extension in 16, 17, and 18. If it was their belief that they could not go forward with this application until such time as the landfill issue was resolved, why didn't they seek a tolling back in 2016 under the statute you're now seeking a tolling for in 19?
You know, I did not represent my client on those extensions, and I can't tell you the reasoning, but if I had represented them, I certainly would have gone after the 3 statutorily available one-year extensions before utilizing something which is a little more difficult, like this tolling provision we're speaking about now.
Okay, so I'm going to ask my question again that I asked your expert and didn't get an answer to. Is it the applicant's contention, based on this application for tolling, that if the municipality does not, or DEP does not address the landfill issue, your client will never be able to develop the site?
Is that an answer you can provide, Mr. Schlock? Is that? I mean, I think that's part fact and part law, so maybe he can address whatever part he's comfortable with.
The issue is the part fact part. The law is, on the statute you're citing, is the argument that you cannot develop the site until such time as the impediment is remediated. So my question is, if the impediment is never remediated, is it your contention your client can't develop the site?
That's all right.
without,
So, hold on, John.
the difficulty to answer that question with certainty is that I don't know what may or may not have extended onto my client's property. If it is extremely contaminated, and it may indeed render it unusable. But because the township has not completed its obligation to finish the investigation, we don't know how far it extends.
Right. But I think at this, because I mean, I think we all understand we got an issue over this landfill or whatever, but really the question coming, and I think, and correct me if I'm wrong, Eric, the provision for this tolling is that you can't develop it because of X. And I think what this board needs is the objective evidence that says I can't develop it because of X. And I haven't really heard anything that's indicating that, and I guess, go back to council, that we're coming, in theory at the 11th hour, but I would have expected to see some type of, perhaps just simple soil testing on your part, just to give some hint of objective evidence that, that you've come across that you could state, or, that you cannot develop your property. And I'm really at a loss right now to hear anything otherwise at this point, other than some, hypothetical maybes that are out there.
Well, there really is nothing hypothetical, Chairman, about the obligations of Hillsborough Township under the 2000 agreement.
I understand, there's
clean up the
obligations,
site
but where does that
and to-
state that it prevents development of the, of Block 185, Lot 1 at this point? We can dispute, obligations, and there's going back 20 years, there's all kinds of different people on the wall there that were involved in it that are no longer here, but still, what we're looking to hear from is the objective evidence that you can't develop your land, that will justify granting of this tolling period.
May I elicit some testimony from one of the principals in Guastella Family Associates concerning that? Mr. Guastella?
And
Hello?
swear you in?
Testimony you're about to give the truth, the whole truth, and nothing but the truth?
I do.
State your name, spell your last name.
John Guastella Jr.
John?
You can actually pull the mic out.
Does this work?
Is it working?
You can pull it, you can even pull it out.
John Guastella Jr., Guastella, 312 Wayland Street, Manville, New Jersey.
All right, Mr. Guastella, your family has owned this property for many, many years, since it was transferred by Hillsborough Township, correct?
That's correct.
And you're listening to the discussion between the board and the question asked by the chairman of the board. Can you respond a little more to the questions about whether you're able to develop this property while the landfill sits there unremediated?
I doubt very highly that anyone would undertake a development under these conditions. We've been trying to sell this property for years, and anyone who has come to understand the situation that this property is in, involving this landfill, won't touch it. And I'm talking about serious developers, people that you know and have had before this board. There's no doubt that this landfill has impacted this property adversely. I mean, I don't know how anyone in their right mind could not see it. Okay, besides the time that we've wasted here and lost with this because of this landfill. We were sold this landfill and it was not disclosed to us. Put yourself in our shoes. Okay? And then when this comes about, my father decides to be a nice guy and sit down with you people and try to work out a deal so as not to sue you, not to make trouble, but to make this work. Instead, we have this agreement here that people refuse to even acknowledge. You have an obligation here.
All right, let's go back, though, to the precise thing that we're discussing right now, which is the marketability of the property given the unremediated land.
I think it's the development, though, not the marketability, right? There's two different things. We're talking about the capability of development, not marketability. Two different
Very
things.
good, right.
Okay.
then I would have to admit, one can go ahead and proceed to develop the property. We have not received our final approvals on our wetlands, so that still remains to be seen. Now, should we fail, then we're going to be back here. And we're going to still have to deal with this landfill.
If I could add to John's point, and I know it's not a marketability discussion, but if the applicant retains ownership and is looking for industrial users, any of those more sophisticated users, if they are going to lease those properties, independent lots or buildings back there, are going to perform some due diligence, whether it be to satisfy a lender, their partners, whatever obligations they have, they're going to be required to perform due diligence. That due diligence is going to be performed in accordance with New Jersey DEP regulations, and in that due diligence, you're going to see a landfill that, certainly for those properties that are immediately adjacent to the lot one, their database searches are going to identify the same thing that we identified, a landfill that has not been closed, just a giant question mark in terms of liability of what is next door to your property. It's going to scare away any potential tenant of those properties.
On the board? Eric, David?
Question, can you give us a little more detail on why you're requesting another 4.5 years? What do you expect to happen in that time frame?
Well,
As opposed to, let's say, a 1-year extension?
Well, we were looking for, just coming back to the board once, and when I said 4.5 years, I meant to qualify it as 4.5 years or less than that time if the township remediation is completed in a lesser period of time. So, Mr. Maskey, if the township remediated and got its okay letter from DEP in 2 years, then the extension would be limited to 2 years. I really had no way of assessing how long we needed, given the fact that the work is under the control of the township.
And going forward, then, if at the end of that 4.5 years nothing has changed, what would your client do at that point?
I assume we'd be back here, but I really have no way of assessing that. I can't believe that the township would sit on this for another 4.5 years.
Thank you.
Eric, what options do we have in front of us?
One more item
Okay.
for purpose of the record. I'd like to, we batted around the agreement between the parties. I'd like to read the paragraph in question, and counsel can correct me. Subject to the terms and conditions of the indemnification agreement, which are attached as Exhibit C, owner shall convey the landfill area to Hillsborough. This conveyance shall be made upon the approval of the amended subdivision plan by the planning board after the conveyance and subject to the terms of Exhibit C, which is an indemnification agreement. Hillsborough shall effect the closure of the landfill as may be required by the New Jersey Department of Environmental Protection. The parties acknowledge that a portion of the landfill is located within the clear zone of Cupper Airport and therefore is subject to development restrictions imposed by the New Jersey Department of Transportation. A copy of the permit for creation of prohibited land use within airport service area dated August 1, 1994 and issued by the New Jersey Department of Transportation to John and Pauline Guastella is on file with the Hillsborough Township Planning Board. The conveyance shall be by bargain and sale deed with covenants and grantors acts. I will also indicate that the provisions of the settlement agreement have the typical no admission of wrongdoing, no admission of guilt in a subsequent paragraph regarding both parties. So it's not a liability issue per se. So it's up to the board. If the board is inclined to grant an extension, the question is, do you want to grant a 1 year? Do you want to grant an extension of 1 year? Do you want to deny the extension? I will point out that, again, we may or may not be back at this at some point again, so it's up to the board.
Would it be an option, or could we put in I mean, I'm inclined for 1 year with the provision that if the 1 year comes and goes, that the applicant comes with objective evidence that they cannot develop. And I mean, real evidence, nothing hypothetical, nothing in regards to marketability, you know. But we have to deal with facts here, and the tolling provision, to me, and correct me if I'm wrong, objective evidence that it can't be built.
Well, it's a combination of ready, willing, and able, and
Right.
inability.
Right. But I think we need to have the objective of the inability that's lacking right now to do a toll, you know, tolling at this point.
I think we recognize the issues with landfill. At this point, I think 4.5 years is simply too long to figure out what the ultimate, what we're going to do with both landfill and the surrounding properties. But I certainly don't want to further impair by not granting anything. So I think there's an opportunity here to grant an extension and allow some additional time to develop some kind of plan to move this forward, or to come forward, as the chairman indicated, with something that indicates the ability to not move forward with the development, recognizing that that was not something we were prepping for. So I know you can't have that for this evening, but I think an extension is warranted. I'm inclined to do a year as well, and at least gives us the opportunity to revisit and come back to the table if we need to.
Any additional comments from Deus?
No, I agree that the extension should be warranted, absolutely.
I would ask, obviously, the extension, so it gives us obviously some time to clarify what your LSRP is actually moved from the solid waste side of the LSRP, which our engineer came back with a report that you did not have time to review, so it gives you time to review that and give everybody the opportunity to see what that entails and what requirements that have, and then possibly give the Castell family maybe some time for you to do some small boring samples on your properties to see if there is any cross-contamination that you could bring to us with evidence that there, even if we don't have the opportunity to get the full cap done, that there is some cross-contamination across the property line that would now give us some hard evidence that there is some issues, good or bad, that Mr. Castell could then know for sure. But I don't think that we're looking to not remediate the situation. We just want to make sure we have everything done the correct way for both sides.
I'd say, my opinion, I mean, if there's any way to perceivably, legally grant an extension through 2023, that would be my preference. But if it's not conforming to statute or to what Mr. Bernstein is advising, you know, certainly an extension one way or another, I would be inclined to.
Okay, if there are no additional comments from Deus, I'm going to ask for a motion to open to public.
So moved.
Second.
Okay, all in favor?
Aye.
Aye. So if anyone from the public would like to ask questions of any of the witnesses, two witnesses, please come to the mic. Okay.
Okay.
Seeing none? Close public.
Motion to close.
Motion to close.
So moved.
Second?
All in favor?
Aye.
Okay. All right, it looks like there is some willingness to do an extension.
Well, the issue is time frame. From what I'm hearing from the board, at least a majority of the board who's spoken, you're looking at if we're back in the same situation a year from now, the board could grant a continuing tolling to 20 fill in the blank or beyond, but I think everybody needs to, the board's looking for some more, I think to quote the chair, objective evidence.
Yep.
For a longer extension.
Excuse me.
Correct.
Somebody needs to make a motion.
I'll make a motion for a one-year extension.
I'll
I just want to
second
make
it.
sure that, as the applicant, are you finished with any testimony, comments? Before.
Yes, thank you, Chairman.
Okay. All right, sorry, who was?
I'll make a motion for a one-year extension for the applicant with the provision to give time for both sides to look further into the evidence needed, required, and process needed to be done.
Could you add on there, in case it isn't done within that year, we could look forward into, another extension?
They'd have to
if
come
needed.
back.
Okay.
Second it.
Okay,
Mr. Hestag.
Mr. Estes. Okay, is there any additional comments from the dais on the motion that's been proposed and second? Okay. So seeing none, roll call, please.
Everybody.
Okay. Mr. Scorbo.
Did you say, yes?
Mr. Peason.
Yes.
Mr. Lapani.
Yes.
Mayor Delport.
Yes.
Mr. Wagner.
Yes.
Mr. Hestad.
Yes.
Deb.
Yes.
Mr. Santaronica.
Yes.
Chairman Sarachi.
Yes.
Who has the applicant's exhibits?
There should be at the very end.
Yeah. The new guy's got him.
You want to send Mr. Maskey a copy, so we just have it for the record?
Big legend.
We'll give it back to you, you'll take it, but you can get a copy, we appreciate it.
Thank you very much for
Okay.
your time.
Thank you.
Thank you. Thank you.
Thank you.
And do you need 5? Are you good? Okay. You got the equivalent peppermint patties here. Pass it down. Okay. No, we're good. Okay, up next application, Primrose Schools Child Care Center, file number 19-PB-06, MSPB, Block 141, Lot 141, on Falcon Road, and the applicant seeking a preliminary and final major site plan approval, see both variances and waivers to construct a child care facility with associated improvements on the property in the Highway Service Zone District and ASD Overlay District. And I believe it's adjacent to the, or nearby the Quick Check gas station and convenience store. So,
He is talking to the line counselor.
Thank you.
So the man behind us can make us all happy.
so the floor is yours, Councilor.
Good evening.
evening.
Mr. Chairman, Mr. Mayor, members of the board. My name is Jay Holub, H-O-L-U-B. I'm an attorney with Forrest Golden and Foley down in North Brunswick. I'm not David Himmelman. David Himmelman, he's very good friends with Jim Stahl and Pete Lamford of my office, and unfortunately, Mr. Himmelman's mother passed away this week, and he needed some coverage on some planning board and zoning matters, and my office offered to pick it up and help him out in his time of need. So with that said, I'm here representing Primrose School. Okay, who's looking for a preliminary and final major site plan approval for development of Block 141, Lot 16.02, here in the Township of Hillsborough, for the development of approximately 11,848 square foot child care center with associated site plan improvements, which includes parking, utilities, retaining walls, landscaping, lighting, an underground storm water management system, and things of that nature. Part of the application, we're seeking several bulk variances under the Municipal Land Use Law, NJSA 40:55D-70, C2, including front yard setback, height retaining walls, buffer from residential areas, walls, fences, tree removal, areas for signage and parking. I would note for the board, which they may already know, the location of this property, which is on Falcon Road, a little bit from the corner of Opie Road, and I believe it carries the common address of 32 Falcon Road, if I'm not mistaken. It's in a highway service district, and since this is a child care facility, it is a permissible use, so we're just seeking the bulk variances tonight. Just a matter of housekeeping. I believe publication was made of this hearing in the Hillsborough Beacon back on May 17, 2019, and notices sent out on May 20th. An affidavit has been provided to the board certifying to same. With that said, I just would like to confirm with the board that there's jurisdiction to proceed on this matter.
Yes.
Thank you. At this point in time, I'd like to introduce Mr. Matthew Taylor, who is seated to my left. He's a representative of Primrose School, and he'll be my first witness. And I will hand him the microphone, which he'll speak into.
Thank you.
Thank you. Good evening.
Taylor, would you like to raise your right hand? Testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, spell your last name, and indicate your relationship to the applicant.
Matthew Taylor, Taylor. I am the representative for Primrose Schools. I handle development for Primrose along the East Coast.
Thank you, sir. Counsel, your witness.
Thank you, Mr. Ernstein. Mr. Taylor, how long have you been employed with Primrose School?
I've been with Primrose Schools approximately 3.5 years. I've done child care development over a number of about 18 years in total.
Okay. And you had indicated earlier your position with Primrose School in charge of the East Coast development. Could you explain some of the responsibilities that entails for the board?
Sure. We source real estate, do a lot of hearings like we're here tonight, due diligence, environmental due diligence, putting real estate projects together, getting them ready for construction. That's what my group does.
Okay. And if you could explain to the board what Primrose School is and what they do. Absolutely.
So Primrose Schools is based in Atlanta, Georgia. I've been in business about 35 years. This year we actually opened our 400th school. We are in 38 states across the country. We have approximately 22 locations in New Jersey, looking at more development in New Jersey as well. Northern New Jersey is an excellent market for us, well-educated consumer, and our product works well here.
Could you explain briefly what are some of the child care services that are offered there at the school?
Sure. It's traditional child care, but with an educational component. We operate 5 days a week, 6:30 a.m. to 6:30 p.m., no weekend operations, which is nice for a lot of our surrounding neighbors, so we don't exacerbate traffic on weekends, and really the building's vacant on weekends.
And could you explain what are the ages or the age groups of the students that attend the school?
We'll be servicing children 6 months of age to 5 years of age. There will be potentially an after-school program. That's one of those things that comes up usually a year or two into operation, depending on what the local community is looking for. So we don't really know whether that'll be a component yet or not.
Okay. And as I understand it, it's the operation 6:30 a.m. to 6:30 p.m., weekdays only, nothing on the weekends. Could you explain for the board what the staffing situation and employee situation looks like?
Sure. Our maximum occupancy will be a design occupancy of 192 children. We typically operate around 85% when it's a mature school, which is about a 3 to 5 year ramp. At full occupancy, we would have 22 teachers on staff. And that's a rolling staff. You know, people will come and go. Not everyone works a full workday. We try to accommodate people who want to work part-time when their children may be in school otherwise.
Okay. And again, for the benefit of the board, once the school is in operation in full swing, could you explain how the drop-off and pickup of the children works there?
Sure. Unlike maybe what you might see in some day schools locally or an elementary school where everyone's dropped off at the same time, that's not the case. Our pickup and drop-off is usually over a 2.5 to 3 hour period in the morning and in the evening. So from 6:30 a.m. to about 9:30 a.m. in the morning, with a heavier concentration probably between 7 and 8:30. Parents come, physically have to park, bring their child into the school, sign them in, bring them to their classroom, meet their teacher, and return to their car. We've done multiple studies across the country and many here in New Jersey to see how long that process takes, and it's usually somewhere between 7 to 10 minutes per child or per parent. And oftentimes, parents will have more than one child when the school is in fuller operation.
And with regard to the pickup, does that work in a similar manner or same manner?
Pickup is similar. It's spread out a little bit more because sometimes parents want to grab children after they're getting their school-age kids, so it might end up being, 3 o'clock versus a 5 o'clock pickup. But it's a pretty even distribution as well. In the same process, they have to park, go in, sign out their child, and leave.
So essentially, it's not like a typical or a more common school where all the kids would be bussed in at one time and bussed out at the same time?
No, I mean, it's really designed, obviously, for the safety of the child and protection of the child, to make sure that everyone's got custody from the parent to a teacher and back.
And you had indicated that there are no plans currently for any type of weekend activity and that you're vacant, is that correct?
No, and I just want to clarify. I mean, there may be a weekend event every once in a while. Could be a graduation of a class, and typically a graduation would be one classroom or two classrooms, so it might be 15 to 20 children. So it's not a large event. There may be an open house type of thing, but it's certainly not an every weekend coincidence.
Okay, thank you. Also, considering the operation during the week, I assume you expect to have deliveries, and things of that nature. Could you just explain to the board how that would operate and how that would go?
Sure. Our deliveries are usually set outside of our operating hours. We take food deliveries twice a week. They're usually off a panel truck, something the size of a UPS or FedEx truck. The food's all pre-prepared. We don't do any cooking with a traditional kitchen. It's all steamed and heated, pre-prepared food. And that's really the only delivery outside of maybe an office delivery every once in a while, or again, a package being delivered.
And again, the trucks that you anticipate is just generally a UPS or FedEx sized trucks, correct?
Yeah, a panel-sized vehicle.
And then also, could you explain for us what you generally expect in terms of garbage and recycling and how that would operate there at the premise?
Sure. We do participate in recycling programs with our vendors. The typical dumpster size would be a 7.5 cubic yard dumpster for waste and 15 yard dumpster for cardboard and recyclables. We generate a fair amount of recyclables. It's usually an every other day pickup, and again, we try to have them done outside of business hours, but certainly not too early or too late to be frustrating to the neighbors as well.
Thank you. That's all the questions I have.
Thank you.
Board have any questions? Keep it on. We'll get questions.
Any questions, comments from the dais? Open up. I'd like to have a motion to open to
Mr.
public.
Chairman?
Oh, sorry.
Just clarification on the maximum number of children was 195?
Maybe I said 192.
Or 192, I apologize, yeah.
Yeah,
So the
I-
maximum number is 192, but you usually operate at about 85% of that?
Our national average is about 85%.
Well, because I'm just trying to get towards the required number of parking spaces.
Understood.
So with the 192, based on the ordinance, divide that by 10, let's just say you're going to need 20 spaces for the children plus another 22 for your maximum employees. You said 22 maximum employees?
Sure, at full occupancy, correct.
So in theory, you're going to need roughly 42 parking spaces required, and you're proposing 48 spaces?
Correct.
Okay.
And really, to clarify the parking piece, the last thing we want to design is something that doesn't work. We've done it, and I don't want to do it over, because it's frustrating, obviously, for parents, and it's not a safe situation. We find somewhere between 45 and 50 spaces works well for us in a building this size, not just in New Jersey, but in multiple places. So thank you.
Sorry. The 22 staff members, does that include administrative staff or just classroom staff?
That's classroom staff. There would be a school director as well, and potentially a cook. So I guess it's 24 total, yeah.
Thank you.
Man. One quick question, Mr. Taylor. Is there another facility within the area at this time?
We have several, and you're going to challenge my geographic ability here in New Jersey, but I'd have to defer to my civil engineer, who could probably tell me. The most recent one I opened up was in, there's so many of them, I apologize.
Warren.
Mountainside, Warren, those are not real close to you.
The one in Warren, for those of you unaware, is on Mount Bethel Road.
I could provide a list to the board. I apologize. I just came in from Florida. I live in New Hampshire. I got
Not a problem, 'cause I think more for the edification of the board and the public as to where else you've got location. Warren is relatively close.
Yeah, we have several locations around the state of New Jersey.
No additional comments from the dais or from our professionals. I'd like to have a motion open to public.
So moved.
Second.
All in favor? Aye. So if there's anyone from the public that would like to question the testimony of this witness, please come to the microphone, state your name and address. Looks like no rush for you tonight. We'll move on. Counselor, to your next witness.
Thank you, Mr. Chairman. Next witness, who is the civil engineer, Mr. Robert Strecker, in this matter.
Yeah, just, you could take the wireless mic, but first we'll swear you in.
Raise your right hand. Testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you indicate who you are, spell your last name, and by whom you're employed?
Sure. My name's Robert Strecker. That's Streker. I'm with BELLE Engineering in Warren, New Jersey, home to Primrose School on Mount Bethel. I've been with BELLE Engineering for about 13 years at this point. I'm a 1997 graduate of Stevens Institute of Technology in Hoboken, New Jersey, where I received my Bachelor of Engineering degree. Since that time, I've been working as a civil engineer, mostly in the site development field, doing projects similar to this. I have a staff of 11 engineers back at the office. I'm a licensed professional engineer in New Jersey as well as New York. I was qualified by this board a long time ago, but I've been qualified in over 65 municipalities in the state of New Jersey.
Okay. Anyone?
I think we're good.
Has no objections, so we'll accept.
As an expert in civil engineering. Thank you.
Is he going to give planning testimony? You want to ask?
Yes, are you also presenting as a licensed planner or just licensed engineer?
I am not a licensed planner, no.
Okay, thank you.
Good evening, Mr. Strecker. Now that we've gone through your credentials, you've been accepted by the board as an expert in civil engineering. I see you have some exhibits that have been set up. For the benefit of the board, could you just explain the current condition of the property, how it exists today?
Sure, and I do have a couple exhibits I'd like to mark in if I could at the beginning.
Sure.
Okay, so what I'm marking as Exhibit A1,
Mike, close. Why don't you mark it and then describe it?
all right, so Exhibit A1 is identified as an aerial exhibit prepared by BELLE Engineering. It's dated June 13th, 2019. And
This exhibit has not been presented to the board, is that correct?
no, it's not. It's been made for this meeting tonight. The subject property is outlined in yellow, as you see on Falcon Road, and generally depicts the development and the improvements in the area as they are today. What I'd like to mark as Exhibit A2 is a copy of the site survey that was prepared by Control Point Associates. Now, this was submitted to the board. It's an exact copy of what was submitted, and it is dated July 2nd, 2018.
probably push the other two exhibits down slightly.
All right, so what I've marked as Exhibit A3 is a colorized version of Sheet 3 from your plan set. It's been colorized for presentational purposes, with the proposed landscaping superimposed over top. It's identified as an exhibit dated June 13th, 2018. And if you bear with me, I have 2 truck turning exhibits that I'd like to mark in as well.
Why don't you wait for those ones? If the board has any questions regarding these 3, so in case you then want to take them down or put them on top.
Okay.
Can you indicate for A3 what the original exhibit was for before it was colorized?
Yeah, it is a copy of Sheet 3 from your plan set. That's a site plan sheet.
Thank you, sir.
Okay.
Counsel?
Yes, thank you. Mr. Strecker, the current condition of the property, it's in a vegetative state at this point in time. Could you just, do you have?
Yeah, I can speak to, we'll refer to Exhibit A1 and A2 as part of this conversation. The property is undeveloped, as you can see on Exhibit A1. Again, outlined in yellow is where the subject property is located. It's an undeveloped property located at the northeast corner of Falcon Road and Opie Road. This is in the HS zone, it's the highway service zone. The lot consists of 3 acres of land and has no improvements on it currently. To the north of the subject property, it's a commercial yard, also within the HS district. To our east along Falcon Road are residential houses. They are located in the RA district. The Promenade Shopping Center, you can see just across Falcon Road from the subject property, that is in the O2 district. And immediately to our west is the stormwater management basin for Quick Check. The Quick Check convenience store and fuel sales located on the 206 frontage. Interestingly enough, the subject lot was created in a subdivision from the Quick Check lot. So approximately 2009, this lot came to be. And if you remember from way back when the shopping center was under construction, Falcon Road used to traverse the subject property straight out to 206. It was realigned. That created some interesting conditions on the property that the applicant needs to contend with. If you look at Exhibit A2 now, which is a survey, you can see this darker line towards the southern end of the subject property. That is actually where the roadway used to continue through. And there's a drainage ditch and a drainage easement there that was established during the Quick Check application. We also have several other easements which are located in this triangular shape, which actually fronts on Falcon Road. There's an electrical easement, a gas easement, a site triangle easement. It's a very busy section of the property. And that section of the property is also kind of sizable compared to the overall lot. It's about 15% of the total lot area. As you can see, the subject lot, particularly because of the triangular shape that's left over here, is somewhat unique. It's irregularly shaped. It's not really perpendicular to the road that it fronts, and it has a lot of the limitations that I just went through in terms of easements. Also on the property and immediately adjacent to it are 3 wetland areas, and I apologize if you can't see it from your seat, but there's a wetland area in the northeast corner of the lot. There's one that's just off-site on the Quick Check property, but comes over onto the applicant's lot in the northwest corner. And then also there's a small isolated wetland located just off of Falcon Road, closer to the road than the ditch. We have flagged those wetlands. We have submitted for an LOI to the DEP. We've also submitted for transitional area waiver and a number of general permits which would be needed to facilitate development of the property. So that review by the DEP is currently underway. And if I could, one more last interesting bit of information to give the board about the property is when we undertook our geotechnical investigation of the lot, we found that rock is very shallow on this property. It varies between 4 to 6 feet below grade. The soil that's above that rock, although they never encountered static groundwater, they did see evidence of modeling about 2 feet below the surface. So modeling is essentially what the DEP would consider seasonal high groundwater. We need to stay above that. So we have very shallow rock, very high groundwater, and a lot of restrictions and different issues that we need to deal with on this property. It significantly affects the way we develop this site. And if you're good, I'll roll straight into proposed.
Right, that would be the next issue. We know what the current condition of the property looks like right now between the easements, issues with rocks and groundwater, okay, as well as what the neighboring properties all include.
Microphone, please.
Thank you. As well as what all the neighbors are and what zones that they are in. The proposed plan, if you could just explain that and show it to the board, I think that'll help explain things. Thank you.
Sure. All right, so referring to Exhibit A3, which is all the way on the right, again, colorized for presentational purposes. You can see we're proposing an 11,848 square foot Primrose School. As Mr. Taylor just identified, the number of students, max number of students is 192. Max number of employees per shift is 24, which brings the total parking required up to 44 parking spaces. 48 are provided with this plan, so we're compliant with your parking requirement. As we undertook the layout and design of this project, it was a challenge to the design team. We worked closely with Primrose, also with their architect. We had preliminary meetings with the town as well. We also met with the Environmental Commission, and so a lot of hands were into designing this site. There's several points of relief that are required from your ordinance, right? First off, number one is the fact that parking is not permitted in a front yard. With this use and the way the school operates and the way all daycare centers operate, really, is it's important, if not vital, to have the parking in the front yard. You need the parking by the front door, accessible from the street, because we want to separate the children from the vehicles entering and exiting the property to the greatest extent practical. If you are or not familiar with the way daycare centers operate, around the building there's several classrooms. Each classroom has its own access point out to play areas, which are on the exterior. That's the green area that you see on Exhibit A2. And these lighter tan areas indicate playground equipment that's located on the property. The play areas are separated and controlled so appropriate age groups are in appropriate areas. So it's not practical to have the parking lot in the rear of the property as your ordinance requires. From that standpoint, it needs to be separated, and this is the best and the safe way to do that. When we look at setbacks, your code for the HS district sets a very specific parameter for building setback. It identifies 40 feet as a minimum and 70 feet as a maximum. So it really attempts to lock in the buildings closer to the road and pushes parking in the rear. For this site in particular, that is difficult, particularly considering all the restrictions that we just talked about looking at Exhibit A2. The development of this property really can't start closer than 40 to 105 feet from the roadway, just because of the geometry of that triangular piece we talked about and the number of easements that are present. So the building setback here is actually 207.5 feet. So we do not comply with your front yard setback. But the development is as close to the road as we can make it. But again, we're severely limited because of what's existing on the property. But the side and rear setbacks for the building, we're fully compliant with all the rest of those setbacks. One of the other things that we talked to the town and to our own design team with frequently was buffering, and particularly, how do we address our closest residential neighbor to the east? We want to make sure that our closest neighbor doesn't feel burdened or developed upon. Your ordinance requires a 60-foot easement to be provided between residential uses and zones and commercial properties such as this. We do fall short on that dimension. We're providing 51.9 feet on that eastern side, as you can see on Exhibit A3. So we're nearly compliant, but we're not quite there. What we did decide to do, however, was take the parking lot and push the parking lot as far to the west as we can. And we're doing that because we know the adjacent property is Quick Check. That lot is their detention basin. Very unlikely anyone's going to be impacted or even realize that there's a separation or a proximity of the parking lot to that lot line. So we elected, there's a buffer variance on that side as well, but we're electing to request a more significant buffer variance against the commercial property and maximize what we can do to the adjacent residential property.
Does that buffer only apply to the parking lot, or is it for the building as well? The shortfall, is it only applied to the parking lot area, or is it the building as well?
It's the parking lot area. There's a number of retaining walls that are around the parking lot that I'll get into in a little bit and explain how that works. But the building is clear. The other thing that I'm at the point to talk about the retaining walls at this moment, so excuse me for the awkwardness. Because of the shallow rock and the water table, similar to Quick Check, we need to raise the site. So we're controlled horizontally on the property. We're also controlled vertically. We need to raise it above the seasonal high groundwater and above the rock for constructability purposes. Trying to build a building on rock is difficult. Also from stormwater management purposes as well. The discharge point for our site is that ditch, which follows the former street line of Falcon Road. So that ditch is on the surface. So our discharge point has to nearly be at the surface. However, we have an obligation to provide storage for excess runoff. So we're doing that in the front yard, underneath the parking area, and it's an underground storage system. It's a couple concrete arch pipes, or several concrete arch pipes, that create a detention system in that area. So for that reason, we need to raise the grade on the site. There are a series of retaining walls. If you refer to A3, there's retaining walls that wrap around the parking area, around the play areas along the westerly, northerly, and easterly side of the building, and tie back up around the parking area heading towards Falcon Road. These walls vary from, at the driveway, 6 inches in height, to the northern end where they're almost 10 feet, or they are 10 feet tall. Your ordinance only allows walls to be 6 feet in height, so that's a bit of relief that's required as well. The reason why we're utilizing retaining walls in this area is because we want to leave as much of the existing vegetation as we can. We think that the buffer that's afforded to the residential property to the east is good and vibrant. We want to maintain it, and we're going to supplement it additionally. But using the retaining walls allows us to keep the development tight. It allows it to keep it exactly where we need to be. We could grade it out and eliminate or reduce the walls, but we think it's a better plan if we keep the walls as they are. On top, the wall is a modular block wall is what's proposed, so it will not be a cast-in-place wall. It will not be unsightly. It will be an attractive landscape-type wall. On top of the wall will be a 6-foot black tubular aluminum fence. Within the parking areas, there will also be guide rail across the front of the parking stalls to ensure errant drivers don't hit the fence. I touched on the drainage, just some of the numbers. With this development, we're at a 33% impervious coverage on the property. So really not out of line with the development of this size, and we're able to manage it, mitigate it on site. We have an underground detention system, as I talked about before. We also have a mechanical water quality device to provide 80% TSS removal. And due to the depth of the rock and the seasonal high groundwater, there's really no permeability on site. So we are not addressing recharge. We really have no deficiency of recharge. There is, with the quantity reduction for the 2-year storm on this, we need to work with the engineer to kind of make minor correction. I think the way we represented our numbers wasn't really showing the impact that we were having with this stormwater system. So I think if we work with Mr. Euro, we can settle. He has a few comments on the stormwater system. I think we can address them all without an issue. And as I said, ultimately we discharged to that ditch part of our application to the DEP. It's been silted up. It's a little, it needs to be cleared out, essentially. So that's part of our application to the DEP as well. Access to the property is provided via a driveway to Falcon Road. You can see it on Exhibit A3. That's a full movement driveway, so lefts in and out are proposed at that location. The driveway itself is 24 feet wide, curb to curb. However, at the curb cuts on Falcon Road, it's wider. We have curb returns to facilitate and ease movements of vehicles on and off the property. That dimension is 69.9 feet in width. So your ordinance limits driveway widths to 24 feet. The throat of the driveway is 24, but that opening at the curb is larger to facilitate movements. Once you get on the property, it's two-way circulation throughout the parking lot. The parking stalls are all 10 by 20s, consistent with your ordinance. And again, 48 parking spaces are provided. It's in excess of what is required by your code, and that is good from a Primrose and an operational standpoint, because it ensures that there's always a spot. I know there was concern about, is there a drop-off area, how does it operate? I think Mr. Taylor identified how that works. And it's really, the drop-offs and pickups are distributed over several hours. So it's not everyone showing up at the same time and having to fight for parking spaces. Lighting on the property is accomplished by 7 15-foot tall LED light poles. We're utilizing house-side shields on all those lights, and we have 0 foot candles at the property line. And in fact, paying attention to our residential neighbors, we have 0 foot candles within 30 feet of his property line. So we made sure to stay well away from the adjacent property, and I think we've accomplished a good lighting plan in that area. The only location where we come close to the property line with lights is right at the driveway, because we need to illuminate that for safety purposes. Kind of blew through circulation of trucks. I would like to mark in those 2 exhibits now for truck circulation. This will be A4. And Exhibit A4 is a fire truck turning exhibit. This was intended to be submitted to the board, although I'm not sure that it made it to Mr. Euro. We sent him an email copy of this earlier today.
Thank you.
We have been in contact with your fire official and obtained the dimensions for the fire apparatus that he is planning to bring to this site if it's needed. And that is the circulation pattern that we've depicted on A4.
Can you indicate what A4 and A5 are?
Sure. A4 is a fire truck turning exhibit prepared by Bowler Engineering dated June 13th, 2019. As I said, it depicts the Hillsborough fire vehicle as provided by your fire official. Exhibit A5 is a truck turning plan prepared by Bowler Engineering dated June 13th, 2019. This depicts an SU-40, so sort of an oversized garbage truck or panel van. And what both of these exhibits show is circulation patterns on and off the site. It may be difficult for you to see from your seats. However, the fire vehicle can enter the driveways as they've been designed, can circle around the parking areas in the parking lot, clear of any parked vehicles, and can effectively exit. Same thing for the trash truck exhibit A5. It's a smaller vehicle, so it's more easier to maneuver through the parking lot. The trash enclosure itself is located in the northwest corner of the parking lot, so we've depicted the vehicle backing up or pulling forward into that position where they would collect the trash and then leave the site. I'd like to talk a little bit about the landscaping that's proposed on the property. The applicant is proposing 888 new plants on the property. Of that, 83 are trees. Those trees include 23 shade trees being planted at 4-inch diameter calipers. So those are significant trees being planted, 57 evergreen trees and 3 ornamental trees make up the rest of the trees. What we've done with the plan is, again, considering our neighbor to the east, there's a number of significant trees that are in that area. We're proposing to supplement those trees with more shade trees in that area and also fill in the gaps in the existing landscaping buffer with evergreen trees as well. So it's a mixture of deciduous and evergreen trees, really filling the gap, and we think that really helps substantiate the few feet that we're missing on the buffer width in that area. We think that with this planting scheme, we've helped provide what was intended in the ordinance. The remainder of the plantings are distributed throughout the property. We have a ring of evergreen shrubs around the parking area that is to screen headlights. So even though we're up on a retaining wall, we want to make sure we don't produce glare off the site, and we'll accomplish that through those evergreen shrubs. At the base of the wall, we've provided a number of planting beds, particularly on the Falcon Road frontage. You can see them in A3. They represent as brown for the mulch in those areas. That's a mixture of perennials, deciduous, and evergreen plantings. And as I said, we're really focusing on bolstering that residential buffer. There are a number of items in your ordinance that specify how many plants you need to provide based on number of parking, based on a number of different criteria. When we look at that, we're going to fall short. We're going to fall short of the tree replacement requirements as well, and I'll give you the details on that. A lot of the reason why we can't provide the number of plantings that are required within the parking area, again, is because we're in an elevated situation. We have retaining walls around the perimeter. If we simply graded those out, we probably would be able to provide a compliant number of trees. But in grading that out, we would take down more trees. So we don't want to do that. We also have the underground stormwater management system in the front parking lot, which you can see the planted island in the middle of the parking area. About half of that is over top of this stormwater system, so we don't want to put trees there. The other half of that island contains a light fixture, which is giving a lot of light. So really our areas where we can provide additional plantings are fairly limited. We do, however, retain the green space that you see along Falcon Road that's proposed to be maintained. You have a street tree ordinance that requires a street tree every 40 feet. For our frontage, that would equate to 7 trees, and we're only proposing 4 new trees. However, there is vegetation that exists on either corner of our frontage. And again, there's also a number of easements which are in that area which prohibit planting. And really, we've planted a street tree where we physically could. With removals, there are 233 trees that exist on the property. We're removing 163 of them to accomplish this plan. That is 69.9% of the trees. Your ordinance limits the amount of trees to be removed at 60. So we're slightly over that category as well. In terms of replacement trees, 438 replacement trees are required. When you look at the removals, the calculations based on diameter, I'm sure you know there's a multiplier that you utilize to come up with this number. 74 of the proposed trees qualify as replacements. So we are technically short, or officially short, 364 replacement trees on this property. I don't know where those trees could be planted on this property. So what the applicant is proposing to do is make payment in lieu of providing those plantings. It's a wooded lot that's undeveloped currently, and to accomplish this, there will have to be tree removal. Looking at the sign program for Primrose is very modest. There is a single wall-mounted sign. That's the logo that they have over the front door. It's 9.6 square feet in size. And the ground-mounted sign, there's only one ground-mounted sign proposed for advertising, and that is 40 square feet in size, 6 feet high, where you're allowed 15 by your code, and setback 15.7 feet where your code allows 10. I think there are a number of directional signs or miscellaneous signs that were on the architectural drawings that were submitted, but they're not reflected in these signage calculations here.
Sorry, where's the ground sign? At the entrance?
It's at the entrance,
Okay.
yes. Sorry, if I had to step that close to A3, there was no way you were going to see
Okay,
from your seat.
just wanted to make sure. Yep.
Yeah, but it's planted and it's just west of the driveway.
Just to clarify, as well on the signs that Rob was talking about, you know, they're small, sort of reminder type signs, no smoking on the property, no idling, you know, they're more environmentally sensitive signage that it's not a significant amount.
So I've gone through the plan. I've tried to incorporate as much of your professionals' comment letters in my direct testimony and the reasons why we're requesting relief and the relief that's being requested. If there's items in letters or in our preparation that I missed, please let me know. I'll be happy to go into more detail.
I have a question. I'm not sure if Mr. Euro addressed it yet with regards to the retaining walls and the load part of it, especially on the driveway. I'm looking at you have up to a 10-foot high straight wall in some areas, but in the driveways, maybe not, but your load is within 7 to 8 feet of the edge of that retaining wall, which may require a tiered wall and/or a severe setback, and I didn't see any engineering plans submitted for the type of wall or how they would address that. Have you seen that, Mr. Euro, at all?
That is correct, Mr. Lapani. We do have a comment in our letter indicating that full structural calculations will be required for review by the township engineer as part of the application. And just to follow up on that comment, knowing that these are high retaining walls, ranging from average 4 to 10 feet, they will be tiered, they will taper back, and you will have geogrid tiebacks extending into the parking field. How is that going to impact your underground detention basin that is set roughly 7 feet from the easterly retaining walls?
I don't think it's going to impact it. We'll look at the final design when it comes around, and we wouldn't engage design of that yet until approval was received, and then because a modular block is a proprietary system.
Understood.
So-
Can we approve
but-
something that hasn't been designed yet, though? I mean, they have to, I guess, if based on the approval, it'd have to be approved by you.
The condition that it would have to meet the requirements, and if it doesn't,
And
they'd
it's-
be back before the board, or they decide to go with a concrete poured wall.
Right. The other question I had was on the southernmost wall, it looks like it's actually infringing right on the easement line. Is that permissible on the drainage easement? And possible concern for erosion of that footing of that wall, if we should have any kind of severe flooding or?
We'll take a better look at that and make sure. That easement is for that ditch that we talked about
Right.
earlier. That ditch is really there to serve our property. So if we need to modify anything to ensure erosion is satisfied, we need to do so.
Mr. Chairman? Mayor? Yep. Just a general question first. You require roughly 20 variances, ranging from bulk variances to parking to landscaping to fencing and walls, et cetera, et cetera. Are you planning to provide any testimony tonight regarding the positive and negative criteria that justify all those variances?
Like,
The engineer can testify to some of the positive and negative criteria, but we don't have a planner here tonight. Between him and Mr. Taylor, I think it'll be more than satisfied, or shown before the board that it is satisfied.
Is he testifying then as an expert in planning and zoning?
No, he's not, just in the specific area of the civil engineering.
And
If I could for the board, just to clarify a couple things, and again, this is just more of an operational thing for us. I realize that some of the variances we're looking for, obviously building setback, parking in the front, things like that. This is really an ideal operational scenario for education and for childcare. It keeps the building away from existing traffic on Falcon and Opie Road and keeps...
Yeah, I'm sorry to interrupt, but this is not official testimony regarding
No.
positive and negative criteria. And if you're saying this is your standard way of doing it, that doesn't justify why you don't meet our ordinance. Basically, your plan is kind of inside out. Everything that's supposed to be in the front is in the back, and everything that's supposed to be in the back is in the front, according to our ordinance. So you need to provide the positive and negative criteria according to the municipal land use law about why all those variances are justified.
I understand that. I was clarifying from an operational standpoint, not as a professional planner. My apologies for stepping that bound.
well, who's going first?
I'll let you go first.
What I was going to offer is that...
Microphone.
You gotta get the mic back up again.
Okay. What I was going to offer is through the direct testimony that I gave, and I'll supplement as necessary. We talked a lot about why decisions were made and why variances are necessary. Particularly, just the one we just talked about, parking in the front yard versus the rear, the building setback. There's a number of issues that created this kind of situation. One of those being the fact that the use itself dictates that kind of layout.
I'm sorry, but isn't that a self-created situation? That you can't meet the ordinance? Are you saying it's a hardship, or that it's a C2 variance, or is it just, it works better for your applicant?
I'm saying that the arrangement and configuration of this layout works for the use that we're here to talk about. So,
It's the only way you use it for it to work?
I'm sorry, I don't
It's the only,
understand.
but you said this works for what you're proposing. Is this the only way it will work?
I'm sure if you had a different situation, you could propose something differently. You could absolutely propose a building up front and the parking and the playground in the back. For this operator and for many other operators similar to this, this is the configuration that makes the most sense from an operational standpoint. The building is set back over 200 feet away from the road. This is not the type of use where you have shopping or people walking up to a store or a restaurant. This is an operation where you have designated people who are coming to drop their children off or pick them up. So in that sense, the layout is kind of dictated by the use. The reason why I think the parking being in the front is not a significant issue is the fact that the parking is elevated somewhat from the roadway. We talked about the retaining walls, the fencing that's proposed around the top of the walls, and also the landscaping that's proposed. So it's effectively shielding visibility of the parking area from Falcon Road as well as from the adjacent properties. So in that sense, I don't see that it would be significantly detrimental to anyone off the property, because I don't know that it would be highly visible to them.
Well, what I have here, or we have here, is an engineer's dream. The ability to give planning testimony without a planner's degree. If every engineer could do that, first of all, two things would happen. We'd have much happier engineers, and no planner would have employment. The municipal land use law requires testimony related to the positive and negative criteria regarding variances of this nature, especially the number of variances being sought. There is no dispute that your client believes that the configuration it's proposing is for its operational needs more beneficial than following the current zoning for that site. And that is not to say that ultimately this board is not going to approve exactly what your client is seeking with all the variances they're seeking. But it's a twofold issue. One, you need to prove to the board, not you, your client needs to prove to the board, that it meets all the necessary requirements for these various variances. The board also needs, for the purpose of the record, to substantiate why it's granting these variances, one or more, for purposes of future reference and/or possible, litigation regarding such, i.e. that the neighbors, while the neighbors, you may be thrilled with the way it's set up, the neighbors may not be. So therefore, with all due respect, Counselor, and I know it's always easier to try to get these things through with as little as possible, and you drew the short straw tonight by filling in, but I think you're going to need some amount of planning testimony, either an engineer with a planning license or a professional planner who's going to come in and at least put on the record the various items that I think are set forth in Mr. Gorman's report, Mr. Mask, and Mr. Yarrow's report, simply so that the record is complete. At the moment, and obviously I will stand corrected by the board, I don't see the board having a major problem with the underlying application. I think it wants to make sure that everybody's is proverbially addressed.
Understood.
Thank you.
With that being said, I have some more specific comment.
Well, I was
Sorry,
just
go ahead.
looking, I think there may be that we've been about 2 hours in, and maybe we want to take a 5-minute bio break.
The question is how much longer, Counsel, is this the last testimony?
This is the last witness for this
So
evening.
the question is, I realize we're getting, but if we're coming to the end, thank you for 5 minutes, break, come back for 5 minutes. The issue.
Well, can you,
Exactly, yes.
you can hold? All right, someone says they can hold, so we will continue.
Just some specific issues and questions. The concern with pedestrian safety in the parking lot, and again, given the nature of the business, children, parents getting the kids to the front door. You have a sidewalk which goes from the front door along the eastern parking stalls, but there's no sidewalk connecting to the western and southern bays. So if you're parked in the southern parking stalls, for instance, closest to the road, you would have to go through the entire parking lot, walk through the parking lot, two-way traffic to get to the front door. One recommendation is continue that sidewalk on the western and southern boundary. The other is to convert the two-way into a one-way loop, which then you could also narrow the aisle somewhat, get rid of some pavement, and take that two-way traffic out of the situation and just have a one-way, just all in the for the purposes of better pedestrian safety. Can you address that?
Sure. I think a sidewalk on the westerly and southerly side, since it would be a more circuitous route to the front door, would likely not be utilized. I think the parking lot, as it's designed, promotes safety. It's highly visible. We're talking about children being escorted by their parents from the car to the door. It's similar to any other business that you have up and down or across the state. So I don't see it as a safety issue or a concern. We could take a look at revising the circulation through the site, make it one way.
Yeah, because
would not want to-
I was, sorry, because I kind of remember that when we had sort of the informal hearings, we talked about doing a single direction, only because I know there was concern getting traffic off of Falcon Road and in there, and if people are worrying about trying to pull out those spots and traffic coming back and forth in both directions, it might impede some of that movement. So I remember some of that, and I remember some discussion about trying to extend the sidewalk too. So it was either that, or maybe we were trying to, maybe some of those spots that didn't have sidewalks, and perhaps they might be the employee spots. I
Well,
believe.
that's what, I'm sorry to interrupt.
No,
Chairman. That was really part of, this design really came out of our initial discussion. Parents are really trained, I guess for lack of a better term, to use, certain spaces. Employees would be parking towards the southern and western boundary, and those other spaces would be left for pickup and drop off. That does provide safe egress for the building with your child. I guess I'm not opposed to a single circulation. I'll be honest though, I feel dual circulation works better for our use. Just, you got a lot of people coming and going and they want to have space to do it in. I don't have, I guess it doesn't matter to me, but I like the way this layout works. If the board wants to see something different, I'm certainly open to it. Rob, is there any reason why we couldn't do it? Probably not, but.
Well, the only item of concern I would have is if you go one-way circulation, usually you want to angle the spaces to enforce a circulation pattern, which would cost us parking stalls.
That's a good point.
And now we have 4 excess, I believe, at this point. So while it's sufficiently parked, it may cost us those additional parking spaces.
Right. But appropriate marking, telling people one way should be sufficient. I don't think we're looking to create angled parking, but
Okay.
I think that could be done with signage or road,
Okay.
directions, or paintings or whatever you want to call it.
One other question for now. Say this driveway is going to be left in and left out, correct? Full directional driveway.
Full directional, yes.
Right, on the site plan, I know you can't see it from here, there is currently a cross-hatching on Falcon Road now in front of this property, correct?
Yes.
And you're going to kind of break through that?
Yes.
But the way you have it on your site plan, you couldn't really make a left in, and making a left out is quite difficult. Have you considered a right in and right out only?
No. No, we haven't.
The configuration you have on the site plan, again, you can't see it from here very well, but the way you have the striping arranged, you actually can't, you're actually blocked, you couldn't make a left into the site the way you have it striped.
I'm struggling because I don't remember exactly how we had it striped. But
Okay.
why don't we could take a look at it? The
Okay.
intention is not to obstruct any movement. If we need to open the striping wider to do so, we will.
Okay.
But we think that location of the driveway, being how it's arranged on the curve, has very good sight distance. The road is wider there. There are dedicated turn lanes as you approach towards the intersection there, so it's naturally wider in that location. We think it's a good spot for the driveway.
I believe, I wasn't at the informal hearing, but I believe you may have discussed vans or buses coming into the site. Will there be any vans or buses coming in?
No, I can take that. The only potential would be a short wheelbase bus that would not be, wouldn't be, may or may not be utilized, I guess is the best way to put it. It goes back to my discussion earlier. If we do a school-age program, then yes, we would be picking up children at local elementary schools. That's to be determined, but there wouldn't be a full-size bus. It would be a smaller, shorter wheelbase bus.
How about the disposal trucks? Waste, waste management, garbage.
Yeah, they would access the site. Their circulation patterns are depicted on A5. As it's configured now, there's no issue with the circulation, no impact to parked cars if they happen to be in the stalls.
That's it for now, thank you.
Mr. Chairman, I have a number of questions, and I guess first, Mr. Strecker, did you have a chance to review my report dated June 10th, 2019? And if so, do you have any specific concerns with those comments? And if not, can you address all of them? And then I have just a couple of specific questions related to that.
How would you like to handle this?
If you read through it and you're okay, and you say you can comply with everything, I'm okay with that. I don't think we want to read through every point by point. That would be monotonous. Like I said, I was wondering if you had anything specific that jumped out at you. Otherwise, I have just a couple items that I just need to hear some additional testimony on.
Sure.
That's fine.
Sure. I think just in section D, it's grading and drainage, where we have what the report that we sent in shows that we're not meeting the 2-year reduction on the property. I'd like to work with you on that. I think we consolidated a bunch of drainage areas that we should not have into that number, so I think we're actually compliant.
That's not a problem. We'll work with your office on that. Can you just touch base on the other utilities that are going to be required and possible conflicts with the retaining walls, underground detention, et cetera?
Yeah, what we've shown for gas and electric are schematic at this point until we get approval, and then we start really determining loads and that sort of thing. Then we'll tighten up exactly where the utilities are going to run on the property. But obviously, we'll avoid the retaining walls, the geogrids, the light poles, and the underground storage as well.
Okay. Will there be irrigation?
Yes.
Okay. The outdoor lighting, just hours of operation on the lighting, is it going to be 24/7, or is it going to be terminated at a certain hour?
No, we typically terminate lighting an hour and a half prior or post-closing.
Okay.
And there'll be security lights. I forget if that was in your letter.
That's
or
fine.
Mr. Gorman's letter, but there'll be some security.
And just to
lights.
clarify too, any of the building lighting, there is some soffit lighting at various areas, but it's all just security. It's pretty benign.
Okay. I think that covers most of my letter, and then just going back to testimony and just some of the items that I jotted down.
So for purposes of the record, the applicant concurs with all the recommendations of the engineer, except as set forth in this testimony just now.
Might I just add an asterisk to that? Mr. Euro's letter, and just for clarification for the record, anything that references section 188, 113.3 is actually a variance, not a waiver. So there's a good 10, 15 dozen variances in here. So if you're saying you're agreeing with everything that's in this letter, I'm not sure what that means in terms of all the variances that Mr. Euro has pointed out. Are you agreeing to correct and not require a variance?
No, we're requesting those variances in that relief.
Okay, with the understanding that you're going to provide testimony at some point, not you necessarily, but someone will provide
Right.
testimony justifying all of those variances.
Yes.
All right.
And thank you, Mr. Mask. And then my last question is regarding the two wetland areas that you identified at the northeast and northwest corners of the property. Understanding that you're going to be doing some buffer averaging, have you submitted those plans to DEP yet?
We did.
Could you please provide a copy to the town and to my office so that we can review? Because I do have some concerns, particularly with the northwest buffer from the quick check. I'm not sure how you're going to do a buffer averaging on that, because normally it has to take place on your property. Otherwise, you're going to be impacting the quick check property, and you're going to then bring that into this application, and that hasn't been noticed for.
Okay.
So you really need to take a look at that and provide us with how your averaging is going to occur.
Okay.
That's it, Mr. Chair.
Okay, thank you. I just have a couple of, well, they're not questions, but since I know Mr. Julian's not here, who's our liaison to the Environmental Commission, just reviewing their report. I don't know if you've had a chance to read the Environmental Commission's memo following the April meeting. They had 3 recommendations in there, and I'm just curious if any of those have been addressed, because
We have no issue with the request.
okay.
I believe we've already submitted we have submitted the stormwater management plan.
Okay. And you'll make the revision to the EIS?
The EIS, that's still pending, but we'll provide that.
Okay. And submit the Phase 1?
And submit a Phase 1.
Okay.
Did you have a chance to go over the fire marshal's report of May 13th, 2019?
Yes.
And you have a positive response to all those issues?
Yes, we did.
Okay, thank you.
So,
We gotta wait
Unless
for a
you-
planner.
Going forward, yeah, I just heard that about planner. I
Well-
don't know if the board's going to have any specific
Yeah.
questions on traffic. Do you want them to bring their traffic guy with them? The traffic engineer? Who prepared their traffic impact analysis, Dolan and Dean?
Bob, have you seen anything that would want to
No,
question
the
the
traffic
traffic?
report is satisfactory to my office.
Okay, all right. So just looking at the time, and I know we have residents here, I just want to open to the public so that at least we don't have to.
Yeah, we never.
Oh, we did, that's right. No one came for the first one. So now, anyone from the public who would like to question or the testimony of the engineer, you can come on up now. Anything that they said? No? Okay. So I think they've gotten an earful already, so. So, I guess, Eric?
So, Eric, do we need a motion to continue?
Well,
We're trying to come up with a
I
date.
think
what
they're
we're
looking for a date.
discussing is the board's dance schedule for the summer months. As the board is aware, the applicant may not. The board does not meet in August. We have an application coming before the board in July relative to an affordable housing project that may, you can only pray, may take 2 meetings. It may take less than 2 meetings.
Obviously, counsel is also the substitute counsel, so I suspect that anything he agrees to is obviously going to be subject to Mr. Immelman's availability et al. The two options, and Mr. Maskey, I'm sure will start to scream at me at option 2, is 2 weeks from tonight, which is the board's normal business meeting, if you can come back with planning testimony.
I think that 2-week adjournment or continuance was something that we would be looking for, and Mr. Newman would try to comply.
Okay. That would, by the way, involve, well, you may agree, that would involve the availability of the majority of you.
Correct, I'm sorry.
Well, you guys are, that's half the battle. The other half the battle is, do I have a majority, do I have a quorum of the board for what is not normally a board night?
I will not be here the 27th of July.
The whole thing.
July.
Anyone other than
I'm
Mr.
sorry,
Wagner?
June,
I
I'm
won't
sorry.
be here either. So you're safe.
No, I won't be here either on the 27th.
Okay. So,
I'll be okay.
Yeah, I'm good.
all right. It appears we're going to have, at least at the moment, a quorum. If anybody has a problem, please let the board know. So based on that, Mr. Chairman, it appears that a motion to continue the application to June 27th, 2019, without further notice is the way to go.
Okay.
I'll make that motion.
Okay.
I'm sorry, who said that?
Mr. Scoba.
Okay, sorry, I was right.
It's okay.
So there's second for the continuation to the 27th without notice.
Nate?
Okay. All right, any additional comments? So just for the residents that are here tonight, you're not going to get another notice, but we will be continuing this application 2 weeks from this evening. Okay, with that, roll call, please.
Mr. Scorbo.
Yes. Scobo. That's okay.
Sco?
R?
Yeah, R is the first name.
I need better glasses. Okay, Mr. Scobo?
Yes.
Yes. Mr. Peason?
Yes.
Mr. Lapani?
Yes.
Mr. Delcor?
Yes.
Mr. Wagner?
Yes.
Mr. Heskag?
Yes.
Mr. Deb?
Yes.
Mr. Santaroita?
Yes.
And Chairman Scalacci.
Yes, and with that, may I have a motion to adjourn?
Just for the board's edification, if there are resolutions that we could have gotten on, or we would like to get them on for the 27th, then I think there's at least one more in the pipeline, folks.
Yes.
So,
Yeah, and just one other heads up. As Eric mentioned, July 11th is scheduled for the RPM development on the Sherman tract, which will, I'm sure, take an entire evening. We were also holding the July 25th business meeting in case there was any spillover. So if you're going to be away in July, please let the board know as soon as you can so we can make sure we can have
What was
quorum.
the first date you noted? The
11th.
July 11th.
there's no meeting in July.
So it's the 11th.
Right.
You're all right.
I already told Deborah.
Okay,
11th I won't be
so can I have a motion to adjourn?
So moved.
Second.
All right, all in favor?
All right.
Aye. Good night, everyone. See you in a couple of weeks.